the lecture on Chapter 6, Legal and Ethical Considerations. So what is the legal and ethical basis for care? A fundamental goal for psychiatric care is to strike a balance between rights of the individual patient and the rights of society at large. Because patients in the psychiatric population experience alterations in their thought, mood, and behavior which may render them less capable of making decisions regarding their care. And individuals with mental illness may need their rights protected through the legal systems. Law and ethics are closely related because law tends to reflect the ethical values of society. It should be noted that although you may feel obligated to follow ethical guidelines, these guidelines should not override the laws. Moving on to the ethical concepts. So what is ethics? Ethics is a study of philosophical beliefs about what is right or wrong in a society. So when you consider ethics, you are considering hard questions. For example, is healthcare a right or a privilege? How should resources be allocated and to whom? So that is ethics, is the philosophical beliefs about what is right or wrong in a society. So what is bioethics? So bioethics is a study of specific ethical questions that arise in healthcare. There are 5 basic ethical principles that are important to bioethics. That is beneficence, autonomy, justice, fidelity, and veracity. Beneficence is a duty to act to benefit or promote the good of others or doing good. Autonomy is respecting the rights of others to make their own decisions. Justice is fair treatment, the duty to distribute resources or care equally regardless of personal attributes. For example, an intensive care unit nurse devotes equal attention to someone who has attempted suicide as to someone who suffered a brain aneurysm. Then fidelity, that is maintain loyalty and commitment. And non-maleficence is doing no harm. Veracity is being truthful, the duty to communicate truthfully, describing the purpose and side effects of psychotropic medications in a truthful and non-misleading way. So those are 5 basic ethical principles in bioethics. What is an ethical dilemma? An ethical dilemma results when there is a conflict between 2 or more courses of action, each carrying a favorable and unfavorable consequences. For example, if you're caring for a pregnant woman with schizophrenia who wants to have the baby, but whose family insists she gets an abortion. To promote fetal safety, her antipsychotic medication would need to be reduced, putting her at risk for exacerbation of her psychotic symptoms. Furthermore, there's a question as to whether she can safely care for the children. If you rely on the ethical principle of autonomy, you may conclude that she has the right to decide. Would other ethical principles be in conflict with autonomy in this case? So that is an example of an ethical dilemma. Looking at the principles of bioethics again, beneficence means do good, autonomy, promoting independence or respecting the decision of the patient, justice, that is fair treatment, fidelity, being loyal to the patient, veracity is being truthful, and non-maleficence is do no harm. In nursing, ANA Code of Ethics plays a key role or gives some code of ethics for the practice of nursing, which are represented in table box 6.1. That is, nurse and all professional relationship practices with compassion, respect for the inherent dignity, worth, and uniqueness of every individual. Second, nurse's primary commitment is to the patient whether an individual, family, group, or community. The nurse promotes, advocates for, and strives to protect the rights, health, and safety of the patient. Nurses' authority, accountability, and responsibility for nursing practice, makes decisions and takes action consistent with the obligation to promote health and provide optimal care. Nurse owes the same duties to self as to others. Nurse, through individual and collective effort, establishes, maintains, and improves the ethical environment of the work setting. Nurse in all roles and settings advances the profession through research and scholarly inquiry, professional standards development, and the generation of both nursing and health policy. Nurse collaborates with other health professionals and the public to protect human rights, promote health diplomacy, and reduce health disparities. The profession of nursing, collectively through its professional organizations, must articulate nursing values, maintain the integrity of the profession, and integrate principles of social justice into nursing and health policy. So these are the principles of ethics that guide nurses. Federal and state legislatures have enacted laws to regulate the care and treatment of people with mental illness. These laws vary from state to state. There was a landmark law which was enacted under President John F. Kennedy, which is Community Mental Health Centers Act of 1963. It promoted deinstitutionalization of the mentally ill. There was a shift in emphasis from institutionalized care to the community-based care. With the advent of psychotropic drugs, more of the patients could be integrated into the community. Next is civil rights for persons with mental illness. Mentally ill are guaranteed same rights under federal and state laws as any other citizens. Incarcerated persons with mental illness are afforded the same protections. Federal legislation providing equality for the mentally ill with other patients in terms of payments for services from health insurance plans also improve access to treatment. This equal payment is called parity. Affordable Care Act, which was enacted in 2010, and Paul Wellstone and Pete Domenici Mental Health Parity Act, which went into effect in 2010, provide for insurance funding for mental illness. Other mental health laws which are used is Humphrey versus Cady in 1972, which established due process in involuntary commitment. Commitment is the process of forcing a person to receive involuntarily evaluation or treatment. The process may differ from state to state. According to Humphrey versus Cady, involuntary civil commitment to a mental hospital is a massive curtailment of liberty requiring due process protections. Again, Fifth Amendment says, no person shall be deprived of life, liberty, or property without due process of law. 14th Amendment again prohibits states from depriving citizens of life, liberty, and property without due process of law. So there are some basic criterion for a patient to be committed by the court, which includes a person has a diagnosed psychiatric disorder, person is harmful to self or others as a consequence of the disorder, person is unaware or unwilling to accept the nature and severity of the disorder, and the treatment is likely to improve functioning. Another law is writ of habeas corpus. It is a formal written order to free the person. The writ of habeas corpus is the procedural mechanism used to challenge unlawful detention by the government. The hospital must immediately submit the document to the court. The court must then decide if the patient has been denied due process of law. That is a writ of habeas corpus. Another important law which is involved in psychiatric setting is least restrictive alternative doctrine. The least restrictive alternative doctrine mandates that care providers must take the least drastic action to achieve a specific purpose. For example, if you can treat a patient for depression on an outpatient basis, the hospitalization would be too restrictive and unnecessary. So whatever is the least restrictive measure should be considered first. Another case which significantly impacted psychiatric care is Olmsted versus Louis Curtis in 1999. So the US Supreme Court made decision in 1999 and states that patients with mental health illness are to be placed in less restrictive community settings rather than in institutions. So Louis Curtis was a woman who was institutionalized for her psychiatric illness. And the psychiatric problem must be established based on the DSM-5, and illness must present an immediate crisis if a patient has to be admitted. Other less restrictive alternatives are inadequate or unavailable, and expectation exists that hospitalization and treatment will improve the immediate problem. So these are some basic criteria for admission to a hospital. So let's look at the types of admissions. So first is informal admission, that is sought by the patient. Then is voluntary admission, that is sought by the patient or guardian. There is a formal application, and in order for patient to be released from voluntary admission, patient has to be reevaluated, and if based on the reevaluation, if the provider feels that the patient needs to be committed, then provider can initiate an involuntary commitment according to the criterion established by the state law. Moving on to the involuntary admission, that is without the patient's commitment, that is known as involuntary commitment or assisted inpatient psychiatric treatment. It is a court-ordered admission to a facility. We already saw there are some criterions which are required because these are state laws, and the criteria for commitment are legal standards under which the court decides whether admission is necessary. These standards include being mentally ill, posing a danger to self or others, gravely disabled, that is unable to provide for basic necessities such as food, clothing, or shelter, and in need of treatment, and the mental illness prevents help seeking on a voluntary basis. Then moving on to long-term involuntary. So if for long-term involuntary purpose, there is a requirement for medical certification, judicial review, and administrative actions are required on a regular basis. Then moving on to involuntary outpatient commitment, also known as assisted outpatient treatment, which is also known as court-ordered outpatient treatment. So assisted outpatient treatment can be used as a preventive measure, allowing a court order before the onset of a psychiatric crisis that would result in an inpatient admission. So order for involuntary outpatient care is usually tied to receipt of goods and services provided by social welfare agencies, including disability benefits and housing. So in order to access these goods and services, the patient must participate in treatment and may face inpatient admission for failing to participate in treatment. And another type of commitment is emergency commitment. So emergency commitment is temporary admission or emergency hospitalization. It is used when people are so confused they cannot make decisions on their own, or for people who are so ill they need emergency admission. So primary purpose is observation, diagnosis, and treatment of those who have mental illness or pose a danger to themselves or others. The length of the time the patients can be held in this temporary admission ranges from 24 to 96, depending on the state. Then a court hearing is held and decision is made for discharge, voluntary admission, or involuntary commitment. So I know that certain hospitals have certain procedures as well. Some hospital procedures say that they have a minimum of 72 hours to respond if the patient gives in writing for release. Which individual may need involuntary hospitalization, which is C. Moving on to the discharge procedures, first one is conditional release. So conditional release usually requires outpatient treatment for a specified period, just to determine if the patient follows the medication regimen, can meet his basic needs, and is able to reintegrate into the community. Next is unconditional release. That is the termination of a patient-institution relationship. The release may be court-ordered or administratively ordered by the institution's officials. Next is released against medical advice. So in some cases, there is a disagreement between the mental health provider and the patient as to whether continued hospitalization is necessary. In cases where treatment seems beneficial, but there is no compelling reason to seek an involuntary continuance of stay, patients may be released against medical advice. So what are some patients' rights under the law? So one is right to treatment. In 1964, there was a Hospitalization of the Mentally Ill Act, which says medical and psychiatric care and treatment must be provided to everyone admitted to a public hospital. And the treatment must meet the following. There's a human environment, qualified and sufficient staff must be there to provide adequate care, and there's an individualized plan of care. So every patient has a right for treatment. That's a fundamental right of a patient. Right to quality care. Next right is right to refuse treatment. Patient has the right for treatment and right to refuse treatment. There is a right to withhold consent. Patient can have the right to withdraw consent at any time. Patient has a right to retract consent. It must be honored whether verbal or written. And the right of the patient who is mentally ill to refuse treatment with psychotropic drugs has been debated in the courts. So based on various cases, Rogers versus O'Kane in 1980, Mills versus Rogers in 1982, and Rogers versus Commissioner of Department of Mental Health, 1983. They all ruled that involuntary hospitalized patients are competent and have the right to make treatment decisions unless they are judicially determined to be incompetent. So these decisions say that even if the patients are involuntarily hospitalized, if they are competent, they have the right to make treatment decision. Forcible administration of medication is justified in an emergency if needed to prevent violence and if other alternatives have been ruled out. And these decisions said that a guardian may make treatment decisions for an incompetent patient. Forcible medications are justified to prevent the patient's deteriorations. But patient's right must be protected by judicial determination of competency or incompetency. Another important patient's right is right to informed consent. So according to Canterbury versus Spence case in 1972, the patient has a right to self-determination. An adult with sound mind has a right to determine what shall be done with his or her own body. A true consent to what happens to self. There is an informed exercise of choice. So, based on Canterbury versus Spence, there are some elements of informed choice. So, one is the patient must be informed of the nature of the problem or condition. The patient must be informed of the nature and purpose of a proposed treatment. Patient must be informed of the risk and benefits of that treatment. Patient must be informed of the alternative treatment options. Patient must be informed of the probability that the proposed treatment will be successful. Patient must be informed of the risk of not consenting to treatment. So these are some elements of informed consent. So what is implied consent? So if a clinician approaches the patient with medication in hand and the patient indicates a willingness to receive the medication, then implied consent has occurred. So state psychiatric hospitals generally require informed consent for every medication given. General rules to follow: the more intrusive or risky the procedure, higher the likelihood informed consent must be obtained. Moving on to the rights regarding restraint and seclusion. So most state laws prohibit the use of unnecessary physical restraint or isolation. So behavioral restraint and seclusion are authorized as intervention If behavior is physically harmful to the patient or a third party, alternative, less restrictive measures are insufficient in protecting the patient and others from harm, and decrease in sensory overstimulation is needed, and patient requests seclusion. Nurses must consider the following before using seclusion and restraint. Nurses must consider verbal intervening, should try to reduce stimulation, should actively listen, provide diversion, and offer PRN medications before considering seclusion and restraint. The American Psychiatric Nurses Association promotes a culture that minimizes and eventually eliminates the use of seclusion and restraint. So nurses in psychiatric settings encounter provocative, threatening, and violent behavior from patients. So use of restraint and seclusion might be required until a patient demonstrates quieter and safer behavior. The nurses in the psychiatric setting should understand intentional torts of battery and assault and false imprisonment. So what are torts? Torts are civil rights that are done against a person. So when a person wrongfully harms another, the injured party or the plaintiff can seek money for damages from a responsible party, the defendant. That wrongful harm is called a tort. So the intentional torts are willful or intentional acts that violate another person's right or property, which includes assault, battery, and false imprisonment. Assault is the intentional threat designed to make another person fearful that you will cause them harm. That is, making verbal threats are assaults. You will never get out of here. Or pretending to hit a patient are examples of assault in a healthcare setting. Battery, on the other hand, is actual harmful or offensive touching of another person. You shoving a patient from behind to hurry them is an example of battery. Next is false imprisonment. False imprisonment occurs when a person is confined in a limited area or within an institution. The charge of false imprisonment may be made after a person is placed in restraints or seclusion. Medication that results in chemical restraint may also fit in this category of tort. So use of seclusion and restraint is permitted only under the following circumstances. There is a written order of a physician and is confined to specific time-limited periods, example 2 to 4 hours. And the patient's condition is reviewed and documented regularly every 15 minutes. So the original order may be extended after review and reauthorization. Review and reauthorizations are typically conducted every 24 hours. It must specify the type of restraint. Whereas the 2-point restraint or a 4-point restraint. In an emergency, the nurse may place the patient in seclusion or in restraints, but must first obtain a written or verbal order. A telephone order is acceptable, but must be followed by a written order in the chart with physician follow-up and a physician signature. The criterion for using restraint or seclusion is when an emergency situation exists. There is an immediate risk of harm to the patient or others. One exception is when the patient requests seclusion or timeout. And the patient must be protected from harm. The following must be documented. What is the behavior that led to the use of restraint, the time patient was placed in and was released from the restraint or seclusion. Patient must be monitored through continuous observation. You must assess the patient in restraint at regular and frequent intervals and promote physical needs, food, hydration, toileting, safety, and comfort. And you will document the observations every 15 to 30 minutes. While in restraint, the patient must be protected from all sources of harm. Again, to emphasize, the patient must be assessed at regular and frequent intervals for physical needs. Example, food, hydration, toileting, safety, and comfort every 15 to 30 minutes. Patient may be removed from restraints when safer and quieter behavior is observed. And patient is observed and observations must be documented every 15 to 30 minutes. Now let's discuss the rights regarding confidentiality. So confidentiality is an ethical responsibility of a healthcare professional that prohibits the disclosure of privileged information without the patient's consent. So discussions about a patient in public places such as elevator and cafeteria should be completely avoided. Even if the patient's name is not mentioned, such discussions can lead to disclosure of confidential information and liability for you and the facility. Your paperwork should never contain full patient identifiers. So release of information to a patient's employer about a patient's condition without the patient's consent is breach of confidentiality. It's invasion of privacy. It is violation of Health Insurance Portability and Accountability Act. Discussing the patient's history with other staff members to determine consistent treatment is not a breach of confidentiality. Now let's discuss about patient privilege and HIV status. Some states mandate healthcare providers to warn a spouse if a partner tests positive for HIV. Nurses must understand the laws in their jurisdiction regarding privileged communications and warnings of infectious disease exposure. There are rules of confidentiality or rights, including HIPAA and right to privacy and right to confidentiality. So HIPAA, which was enacted in 1996, which stands for Health Insurance Portability and Accountability Act, it protects the psychiatric patients' right to receive treatment and to have medical records kept confidential. But there are other exceptions for this confidentiality. One is duty to warn and protect third parties. That was based on a landmark decision in 1974 by Supreme Court. The case was Tarasov versus Regents of California. So Tatiana Tarasov was a student of University of California where Prasenjit Podar was a college mate. Prasenjit Podar liked Tatiana, and when Tatiana refused Podar's request for being a couple, Podar became angry and he went for counseling, and he said that he was angry with Tatiana. So it's like so he said that he wanted to kill Tatiana, but the psychologist notified the police verbally and in writing that the young man might be a danger to Tarasov. Police questioned the student, found him to be rational, and he promised to stay away from his love interest. But after 2 months, he stalked and fatally stabbed Tarasov. Based on this background history, this Supreme Court made the decision that psychotherapists or any kind of therapists have the duty to warn and protect the third parties, because Tatiana Tarasov was never warned, but even if the police was informed. So when a therapist determines that a patient presents a serious danger of violence to another, therapist or psychotherapist has a duty to protect that other person. In fulfilling this duty, the therapist may be required to call and warn the intended victim, the victim's family, or the police, or to take whatever steps are reasonably necessary under similar circumstances. So what do staff nurses have to do? So staff nurses are obligated to report a patient's threat of harm against specified victims or classes of victims to other members of the treatment team. APRNs in private practice who engage in individual therapy are obligated to warn the endangered party themselves. Then coming on to child and elder abuse reporting statutes. So all 50 states and District of Columbia have child abuse reporting statutes. So even though the definition varies, Most statutes include civil penalties for failure to report. Many states specifically require nurses to report cases of suspected abuse, both elder and child abuse. So that is duty to warn and protect third parties. So it ruled that psychotherapist has a duty to warn a potential victim. There's a second ruling based on the case that is known as duty to protect. So there is a duty to warn and duty to protect. So the duty to warn usually includes the following: assessing and predicting a patient's danger of violence toward another, identifying specific individuals being threatened, identifying appropriate actions to protect victims. Why is it important again in nursing? Because duty to warn third parties is applied to advanced practice registered nurses and psychiatric mental health nurses in jurisdictions that have adopted the theories of doctrine. Staff members and members of the mental health team should report threats of harm. Again, child abuse reporting statutes, which is established in 50 states and Washington, D.C. Most statutes include civil penalties for the failure to report. Many states require nurses to report cases of suspected abuse. So elder abuse reporting statutes, it applies to older adults 65 years of age and older. Many states require registered nurses to report abuse. Federally funded agencies, Medicare and Medicaid, have strict guidelines for reporting and preventing elder abuse. Coming back to the torts, we already saw the intentional torts, which are assault, battery, and false imprisonment. Now we move on to the unintentional torts. Okay, so what are unintentional torts? These are unintended acts against another person that produces injury or harm. So there are two types of unintentional torts. One is negligence and other one is malpractice. So negligence is a failure to use ordinary care in a professional or personal situations when you have a duty to do so. So malpractice is a negligence from the part of a professional, like a healthcare professional. That is called a malpractice. So in order to prove malpractice, there are 5 elements. One is duty, then is breach of duty, then cause and effect, cause and fact, proximate cause, and damages. So duty is measured by the standards of care. A nurse has to perform a specific standard of care when you deal with a patient. And breach of duty is the conduct that exposes a patient to unreasonable risk or harm by not following the standard of care. That is the breach of duty. So substandard institutional policies do not absolve the individual nurse of responsibility to practice on the basis of professional standards of nursing care. So we said that there are unintentional tort, that is unintended acts against another person that produce injury or harm. Negligence is a tort, unintentional tort done by a person. But malpractice is an unintentional tort done by a professional, healthcare professional. Okay, that becomes a malpractice. So in order to establish malpractice, we should establish duty, breach of duty, cause and fact, proximate cause, and damages. So we already saw there's duty means standard of care, breach of duty means failure to follow the standard of care, cause and fact is because the staff did not follow the standard of care, patient had an injury because of the behavior, and damages, and there was an actual injury because of the failure to follow the standard of care. Next important aspect in nursing is documentation charting. What are the purpose of medical records? It provides accurate and complete information about the care and treatment of patient. Care not documented is care not done. Give healthcare personnel a means of communicating with each other. It allows for continuity of care. So what are the uses of medical records? So rather than just providing information on patient care, the patient care records can be used for quality improvement. It serves as evidence. And what are some nursing guidelines for computerized charting? It should be accurate, it should be descriptive, and should be legible. And that serves the best interest of the patient, nurse, and the institution. Most of the hospitals now have electronic medical records, and the staffs will be assigned passwords. I think all of you have a password to access records of the patient in Epic or in other systems, and penalty is imposed for accessing an unauthorized record. And you have to maintain privacy of the patient at all times. So which of the following identifies the titles that registered nurses will use and what they are legally allowed to do so? The answer is state boards of nursing. So nursing as a profession is regulated by state boards of nursing, professional associations, policies and procedures from various institutions.